Hello friends, myself Harshit Batra, and here I am going to discuss the famous case of Mrs. Balfour versus Mr. Balfour 1919. In this case study, Mrs. Balfour is a plaintiff and Mr. Balfour is a defendant. In this case study, the fact is that the plaintiff and defendant was a married couple. The defendant husband and the plaintiff wife lived in Ceylon, which is now known as Sri Lanka, where he worked. In 1915, the defendant was on leave. The couple went to England. When it is time to again go to Ceylon, the plaintiff was advised not to return because of her physical health problem. Prior to the defendant leave, the defendant promises to the plaintiff to pay Euro 30 per month to her for support. But later on, the defendant has stopped sending money to the plaintiff. The plaintiff brings suit to enforce the defendant promised to pay Euro 30 per month. Now the issue was that does husband promised to pay Euro 30 per month to wife shall be considered as a valid contract which shall be sued upon. The court held that promise made between husband and wife and any other family person according to Indian Contract Act. The promises made by husband and wife and other family members is considered as domestic or social agreement, hence it is not a contract. Now the court held that as it is domestic contract, the defendant Mr. Balfour was not supposed to pay Euro 30 per month to his wife Mrs. Balfour, as there is no intention to create legal relationship. So here the conclusion is that as there is no intention to create legal relationship between husband and wife, that is Mr. Balfour and Mrs. Balfour, Mr. Balfour husband is not bound to pay Euro 30 per month to his wife. Our second case study is Shuppu Ammal versus Subramaniyan. In this case study, Shuppu Ammal is a mother and a plaintiff, and the Subramaniyan is her two sons and the defendant. In this case study, the fact is that at the time of partition of HUF, that is Hindu undivided family, on the death of the father, the two brothers agreed that they would jointly invest a certain sum of money in equal share in some government securities, and the income arising out of that government securities will be given to their old mother for her maintenance expense. But later on, the brother stopped investing money. Now the mother filed a suit against her two sons for investment in government securities and to pay her income arising out of that investment. Now the brothers contended that their mother is not a party to contract, thus she cannot ask her two sons to invest in government securities or to pay her income arising out of that investment. The court held that in case of partition or any other family arrangement for maintenance expense given to any family member, the female member has an actual beneficiary right. According to Indian Contract Act 1872, there is an exception to the rule, no consideration, no contract, but the provision has made for family arrangement or partition for maintenance expense. The female member has an actual beneficiary right, and minor for maintenance expense has an actual beneficiary right. Such person is acquired to hold such a post as a beneficiary under the contract. Now in this case, Shuppu Ammal, that is mother, has an post to actual beneficiary right. Thus she can file a suit against her two sons for the performance of a contract. Thus it is a valid contract, and the court held that the two brothers Subramanian has to invest in government securities and pay the income arising out of the investment to her mother. Thank you.